I already said that a married person can keep 70 to 150,000 in countable assets plus their house. Let's say that they also have a lake cabin and they didn't plan 5 years in advance. They didn't put it in an irrevocable trust 5 years in advance. They didn't give it away. So they have that. That's going to be a countable resource, except for, remember, I said that if it can't sell within 20 days, it's disregarded. So that lake cabin won't sell within 20 days, likely, and it won't interfere with benefits. So that's a planning opportunity to keep in mind. Frankly, when we're meeting with clients and we ask them, do you have legacy property? And they say yes. And we're looking at trying to get that out of the couple's ownership sooner than later, if it's appropriate. If it's not going to be one of those cabins that's going to be sold, it's going to be kept in the family. What else can we do for a couple? Let me explain through an example. And we will, if you signed up for the webinar, we will be providing you a couple of handouts that's going to be really helpful. For example, one of them is how couples can protect their assets from long-term care costs. And this is talking about a couple who has more than what the Medicaid standard is, and they want to keep all their assets. How are they going to do that? So, example, let's take a couple, let's say that they are Mark and Mary, and what is going on with them is that they have assets, they own their home. Remember, that's not countable. Their home can be worth $300,000. It could be worth $500,000. It could be worth $1 million. It doesn't matter. It's irrelevant. What is relevant is what do they have that's countable. And in our situation, they are going to have countable resources. Let's say 150,000 Roth IRA, 100,000 403B, 50,000 in the checking account, a 200,000 stock portfolio. If you're with me adding those up, that comes to $500,000. $500,000 is more than what Medicaid says you can keep. But they still are meeting with an elder law attorney who's going to help them keep all their assets. In this situation with Mark and Mary, let's say what's happened is Mark has collapsed. He's had a stroke. He's partially paralyzed. He's gone through rehab. He's getting better, but you know what? He is a bigger guy. Mary's a smaller gal. Mary's 80 years old. She is not going to be able to take care of her husband at their home without probably her falling ill. One of the things that I always like to keep in mind when I'm talking to people about long-term care is the caregiver's spouse is often the one who fails first. We really want to make sure that the caregiver spouse doesn't sacrifice their life. Sometimes I think that that's all, and they have to do that. But we want to make sure you're aware that this couple is going to qualify for Medicaid, and the safest and best place for Mark, sadly, is going to be in that skilled nursing facility. And that's going to run $12,000 to $14,000 a month. And yeah, the couple can afford it for a little while, for a year or more, but you know what? It is going to completely eat into their savings, such that when Mark passes, Mary's not going to have enough money to keep up her house or to have the quality of life that the couple had envisioned for themselves. So fortunately, Mark and Mary come to their elder law attorneys. Fortunately, we've already done their estate planning such that even if Mark has lost capacity, he has the right durable power of attorney in place that Mary can do this Medicaid planning because she has the authority to do it, and her estate plan was prepared, and their estate plan was prepared by elder law attorneys with Medicaid expertise. So what are we going to do? As I mentioned, the house doesn't count. Great. They have one car. Let's say that their car is an old car and they need a better one. Then they sell the old car and then they get a newer car and they use some of their excess money to do so. Let's say that they don't need to spend down any money on anything. Their house is in great shape, doesn't need a roof or plumbing or anything. Their car is brand new, no debt, everything is paid off. Mark is looking at going to the skilled nursing facility. How are we going to get this couple qualified for Medicaid, have Medicaid pay for Mark's care, and allow them to keep their $500,000 in countable assets? Well, we know that they can keep 150. That's easy. What are we going to do with the other $350,000? Most people will spend it down. And candidly, attorneys that don't do Medicaid planning might give that same advice. Fortunately, Mark and Mary are working with a Medicaid expert, a Medicaid attorney with expertise, and we are going to give them guidance to take that extra $350,000. We're going to move it all over into the name of the well spouse, Mary. She is going to buy a Medicaid compliant annuity. What that means is that's the annuity that the state of Washington allows that will pay back to Mary over 60 months. Every month for 60 months, she will get a payment. So if it was $360,000, I didn't do the math on this before. I'm sorry for not doing that. So if we took $350,000 and divided it by 60 months, she's going to get $5,833 back every month. That money's coming back to her. That money does not go to pay for Mark's care in the care facility. Only his income does. And what his income doesn't cover for his care costs, the state of Washington, through the Medicaid program, covers the rest. Mary gets to keep her house. She gets to keep the car. She gets to keep the $150,000. And she gets to keep all of that money that comes back month by month by month by month back to her, and does not need to contribute any of that to Mark's care. This is the state of Washington's rules. If you're listening from a different state, as a reminder, your rules can be completely different than what I just described. But for the state of Washington, if you are a resident and you are a couple and you have a house worth $1 million, and you have $500,000 in countable assets, and one of you needs heavy duty, high cost, long-term care, an annuity often is a Medicaid compliant annuity, often is the best plan that we will recommend for our clients, because they get to keep all their assets and get Medicaid. No spend down. We simply converted what was a countable asset to a non-countable asset. That's what I want you to understand, such that if you are ever in that situation, you will see an elder law attorney and not feel like you have to spend down all your money, because with the Medicaid compliant annuity option, you don't need to do so. So that's what I meant when I say couples have great planning options.